All right, good morning, everyone. I think we'll go ahead and get started. We are really excited to be here. Thank you for joining and learning all about avoiding the legal pitfalls of online instruction here today. So I'm going to quickly introduce myself and a little bit about Finli, and then we'll dive right into exactly why we're here. So good morning, and thank you for joining. It's really exciting to see we have some Finli clients on with us today. So for those of you who don't know what Finli is, my name is Kim and I'm part of the Finli team. And at Finli, we work with neighborhood schools and studios to really empower them to focus on what they do best. And we handle everything behind the scenes, like billing, payments, account management, etc. With COVID-19 happening, like most of you, we had to expand our offering to help schools and studios migrate classes offline online, especially to reach a larger audience and create a new form of revenue stream. So during that process, we also had to adapt and learn quickly about online instruction, online learning through technology and through Zoom. And we started getting a lot of questions from you and our clients and others around, what are the legal requirements that we should have or think about when hosting a class online. So that is what led us to today's webinar. And we've aggregated your concerns and your questions. And we're really excited that Eugene from Nano Law Group is going to be able to answer all of those. So just a little bit of housekeeping. It should be about a 25-minute presentation where I'm going to be asking Eugene some of the often heard questions we get from you, and then Eugene's going to go ahead and answer them. And then we'll save some time at the end for some Q&A. At the bottom of your Zoom little kind of side or bottom bar there, there's the Q&A section. Please, as we go through the presentation, type in your questions, and we're going to try and get to as many questions as we can today at the end of your presentation. And so with that, I'll go ahead and pass it off to Eugene from Nano Law Group. Good morning, Eugene.
Good morning. Thanks, Kim. And thank you, everyone, for attending. And hope everyone's doing well, staying safe. I am a partner of Nano Law Group. We are our law firm that services small businesses, technology startups, and some businesses that are larger. But most of our clients are businesses that are in the, all kinds of industries, from restaurants, healthcare, to education. I have a couple of private university clients, and I also have a music school client. And I have also technology startup clients, including Finli. So I'm quite familiar with a lot of these issues from these pre-selected questions that we're going over, and I'm happy to discuss and answer questions today. And like Kim said earlier, this will be a question and answer format. I think that's a better, more engaging format because 25 minutes of legal, legal concepts can go over people's heads, and I start to glaze over after 10 minutes. Want to go to the next slide?
Great. Yeah. No, thank you, Eugene. So like I said, we'll go through like the 7 frequently asked questions we're getting, and then we'll save for audience Q&A. So we'll move to the first part of this.
Great. Okay, so here's my disclaimer. I am an attorney. I've been practicing since 2005. And every time I give a presentation, I have to, have this disclaimer. My insurance requires it too, my malpractice insurance. So yes, this is basically saying I'm not your attorney. I'm actually Finli's attorney, but I'm not even giving them legal advice right now. I'm doing this all for educational purposes and informational purposes. So no attorney-client relationship is formed. Great. So before we go into the question, just want to quickly say that we'll be covering from a high level topics that I see recur in almost every situation. One of these issues pops up whenever I review an agreement or I advise a client on forming a company or in the middle of a dispute. Most of my background is litigation, and I do have transactional experience. So I have basically 2 skill sets that can be used with each other. Mostly on the litigation side, I look at a lot of these issues when there's a dispute, and there's a dispute a lot of times because there's no written agreement, or there's a really badly written agreement between the disputing parties. So we'll be covering these issues as they get raised in each of the questions.
Great.
And next slide. So a little thought exercise here. Want to have everyone sort of imagine that each of your students and customers, and we're talking to a lot of educators and owners of schools today, and studios and instructors, that each of your students and customers have a bubble around them, and they could be several bubbles, and each bubble encompasses those topics in the earlier slide: liability and harm, intellectual property, privacy, online services, payment. All those things are encompassed in each individual bubble, and each customer and student that's coming to you comes with these legal bubbles. My job and your job as a business owner is to create a shield to protect your business and not basically pop each of these bubbles. And so we'll discuss that and what that means when we go to the Q&A. So next slide. And so, as I was saying earlier, the most important legal shield is a legal agreement. Legal agreements can be formed orally or in writing. Most disputes that are expensive come out of oral agreements. I highly recommend at some point either hiring a lawyer, going online, talking to your colleagues, talking to your insurance broker, obtain a copy of some kind of written agreement with your customers and your students. The most fundamental one will be going into the next question, but it's going to be a liability waiver and release of liability agreement. But I strongly advise everyone to have some kind of student or services or teacher services agreement. And basically, this is just an image to kind of encapsulate the idea that these agreements create notice and a legal shield and an evidence, as evidence that you have some sort of arrangement and a set of rights and also defenses in the case that you ever get sued by a student or customer. So let's go to our first question. This is covering waivers and liability.
Yeah, so thanks, Eugene. Yeah, so, one of the questions that we keep getting consistently on the Finli side through our instructors is, okay, I've moved my business online now. Normally they walk into my, brick and mortar store and they sign a waiver there and then. How does that work today when I'm instructing online? Can I use electronic waivers? And let's talk a little bit about what happens if someone was to get injured while I'm instructing, even though they're not necessarily in my place of business.
Yeah, so waivers are necessary. They're part of the legal shield. They're part of what I said earlier, a legal agreement. They are a first line of defense. And I say first line because there's multiple defenses you need to have as a business owner. But this is the most basic and easiest one and low-hanging fruit defense you can have to protect your business in the event there is a personal injury, a slip and fall, an accident that happens as you engage in an online course. They can be electronic, they can be sent by email, they can be sent by DocuSign, they can be sent by HelloSign, any of the e-sign service providers that have a certificate that they can certify that you can e-sign legal agreements. Usually it's DocuSign or HelloSign. Those are very easy to use, very consumer friendly. You could do it by email and send an electronic agreement and have it signed, we say countersigned, have them sign a copy and have you sign a copy as the fully executed or fully signed agreement. And it does apply to Zoom classes. Even if you take your business online, you're still interacting with students and customers. Anytime you have an interaction, whether it's online interface, whether it's through emails even, whether it's through text messages, that's all governed by legal relationships. The legal bubbles are still floating. They may be virtual bubbles, not physical ones, but they're still there. And you still need to realize it's that fragile, it's that present in front of you, these legal issues. Zoom does have their own set of legal terms that protect Zoom. You and the student are not parties to each other with the Zoom agreements. So when you go onto Zoom, look at the terms of use. That's the first legal agreement that Zoom is saying, we are protected, but we're not necessarily protecting all of Zoom users. And they can't, that'd be expensive for them. Same goes for Finli. So Finli can only protect its business, but it can't protect everyone, right? Not every single user is going to be protected if they do something during a Finli or during a course that you teach on Finli and using Zoom. If an accident happens, you have to have a waiver that's between you and your student. And that creates a legal agreement between what we call the parties. The parties here are going to be you, the school, and the student. And I do have a template. There's a question here, what's in a waiver, and do I have a template? I do have a template. What's in a waiver? Well, there's a lot of things in a waiver. For personal injury ones, so there's different kinds of waiver. Let's first tackle the personal injury one, because that's the most frequent question that gets asked is, what is exactly, how's it covering me, especially in injury, in case of an injury. So personal injury waivers will have the name of the parties, so the name of the school. Sometimes they'll have the name of the instructor, and then they'll have the name of the student. And if the student is a minor under the age of 18, then they'll have a parental signature also, and the name of the parents. And then it'll have the actual language of what's being released. So a lot of times there'll be claims arising from personal injury, from accidents, and it'll have it sometimes in caps. And the people I know don't like caps because it looks like you're shouting, but that's exactly what you need to do. The law requires you to shout at your customers because there's special protections for participants, students, and customers of your business. So even if you have a large company, say it's a nonprofit that's quote unquote, they're the one that is the customer and paying, but their members of the nonprofit are participants. Those participants each individually aren't covered necessarily for every scenario by the agreement between you and the nonprofit. You need to have an individual waiver specific to each participant. And yeah.
Yeah, no, great. Thanks, Eugene. And just for everyone on the phone, we'll follow up with that template, that waiver template as well in an email to everybody so you can see what one looks like. And really quick here, we just got a question in that's really relevant. So for email waivers, can they just type their name and send it back? Will that suffice? Or do they have to scan and send back?
I like it to be scanned. You would have to put an extra clause that the email and your digital print in the email suffices. And you would also have to, I would even see if they can print the metadata. And you would have to basically be a technologist or understand what that means. But basically, you want to make sure that it has some sort of authentication that was actually sent from their IP address and it was from them specifically. It's easier to get the print and scan. I think the risk reward there is too off balance in terms of the risk being higher, that an email signature, even with contractual language, may not hold if the customer is a bad actor. And later on, they want to challenge that, saying that it doesn't count as a real signature. That can happen, and why risk it, right? When a scan is very easy, you can take a picture, right, of a signature, and modify and make it look like more like a scan.
Great, thanks, Eugene. All right, let's move right along here to the next question.
Yeah. So what if someone is a youth and minor, right? So yeah. I covered this earlier a little bit. So in the template that I have, and in most waivers I see, it has a special carve out for or call out for minors. If you are a minor, it says you must have your parent sign, and that you are releasing claims. So have a special call out to minors. Most minors are not going to understand what that is. So the parents are going to read it. And it also has a release and identification clause for the parent. meaning the parent is responsible if you get sued by your child or by the parent's child or the guardian's child. So that is a case where the parent's on the hook. And you need to have that because in California, minors can sign agreements. Other states, they can't. The parents have to sign on their behalf. But in California, minors can sign agreements. But it's almost like not meaningless, but it loses its legal force because minors can also disaffirm their signatures. They could rescind it. They can claw it back. And so you want to say in that event, parents, you're on the hook. So
great. So in summary, these waivers need to be put in place for both children and for adult students. And the only really difference here is that parents are going to be signing for the children.
Yes, that's correct.
Okay, wonderful. And I can see questions coming in, guys, so we'll try and get to as many of these as possible. But we're going to move on to the next topic here. Over to you,
next
Eugene.
topic's good. Yeah, so the next topic is going to be covering intellectual property. And so that's why I have the brands up, the logos up. So let's advance to the next slide. So this is in class.
Yeah, so some of the, and we're still figuring out this Zoom thing, right? So, you know, a lot of questions that we get, you know, go around, okay, what happens now on the class, right? So we prevented, we've covered ourselves pre-class, now what happens on the class? So if we can just go to the questions here. The first question that we often get is, can I take screenshots or videos, or can I record during my online class? Or can participants who are also online, whether they be adults or children, take photos? And then, you know, that's kind of first step. But then the second step is, can then I then take those photos and actually use them to promote my business? So Eugene, can you kind of walk us through content-wise online, what is it that, you know, instructors and teachers need to know?
Yeah, so this relates to the actual prior questions on releases. Actually, you can take videos and photos as long as it's used for an educational purpose. I would still have some kind of release and consent in a legal agreement. Now, if it's all taken or obtained through an online interface, such as your website, then your website needs to have a terms of use that says any user content, including photos or videos, can be used by, you consent basically as a user for the company to use it. And usually that general or unlimited release and consent is for educational informational purposes. A lot of teachers and instructors need to take videos and recordings to train their staff, right? To teach, to show how best practices or mistakes that were made in the teaching. So you can absolutely do that. I always recommend though, if you are doing it for social media or for commercial purposes, for promotional purposes, essentially, I always recommend you have a limited consent and release. And that goes beyond the general unlimited release that's in your terms of use or in your teaching services agreement. This will be basically a standalone individual consent and release to use your photograph and image or audiovisual files for promotional purposes. And you should list out what those promotional purposes are, because you have, and this is actually more of a business point, you don't want to have an angry customer a year down the road find out that their image was used and it was viral or was circulated, and now it's on the image of a cover of someone's, you know, band. First of all, if you didn't have a limited waiver release, relying on that general one where you put it into like an agreement when the customer first signed up with you or first accessed your website doesn't cut it, because like I said earlier, these legal bubbles are fragile, and they're even more fragile for consumers. The law really looks at these participants as consumers, as retail consumers that need extra protections. And so if they didn't expect you, that consent and release, that general broad one, to apply to every single scenario, and it could be argued that they didn't expect it to be used for especially commercial purposes, they have rights, privacy rights. The second issue is actually related to more intellectual property and copyrights. you may also get angry as a business owner that you spent all this money and it's now being used by other people to promote their own individual business that may also tarnish. Or what if it's a heavy metal band that has lyrics that you don't condone? That use an image of one of your customers, you'd be really angry. So you actually want to trademark and copyright also some of these images if you spend a lot of money on it, or they're going to be used for a campaign that goes super viral and there's a lot of views.
So it sounds like there's two pieces of kind of paper that everyone needs to have, which is the waiver. And then if you're planning as an instructor to take video, record, or screenshots, a release that your students, your online and virtual students, agree to partake in that. And then if you're using something more commercial or advertising use, then that's almost a one-time release that focus specifically on that campaign so that you're covered for that.
Yes.
Great. So, Eugene, how does that work then if we're going to the next question, specifically with children, right, under the age of 13 or under the age of 18? Are there differences between what we can and cannot do if it's children involved?
Yeah. So online, minors have a lot of rights, especially for online or electronic submissions of photos, or if this was done all electronically, and it probably is. A lot of people are hosting Zoom concerts, right? Zoom studio sessions that are sometimes it's for marketing, but even for educational purposes. You can share this content. You should, again, as I said earlier, have a limited release, have the parents sign. But if you are sharing this content online, which most marketing is happening, especially for schools, digital marketing is huge. You want to make sure that you understand the online privacy laws for minors. And there's one that's going to be relevant, and that's going to be, well, there's actually two. There's COPPA, which is the Children's Online Privacy Protection Act. And then there is the Minors Eraser Law. And the COPPA one needs to just have, in your terms of use, special provisions, special language in there for children, especially under the age of 13, if they're signing onto your website. For the Minor Eraser Law, which is probably the more applicable law here, is if you are sharing images, even if you have a waiver of release, the minor still has rights that they cannot release. I don't think they can release. And that is a right to have their image be taken down. And they can ask for that. And you do have to disclose to them how you shared the image. If it was shared to like a third party, like maybe a digital marketing agency, and the image is residing on their server, and they're using it possibly in promotional content, saying, oh, hey, look, we built this website. And here's the image of the minor. They have to also scrub the image too. So it's really incumbent upon you to really, as a business owner, if you are using minors in any kind of promotional material, just keep a housekeeping, a tracking of where it was being used, where the file's residing, and that's it. Your developer can easily tell you where all those answers, and can easily remove the images also.
So what I'm hearing, Eugene, is that even if there was a photo release being signed for minors, parents can come back and say, actually, I'd like you to remove the image of my child on your website, and you have to comply with that, and also remove it in any other retrospect areas that this photo was in. Yes,
under your custody and control. You can only do so much as a business owner, and the law, yeah. I mean, if this thing goes super popular and gets shared on Instagram amongst a lot of other people, that's a new kind of notoriety, that may be enjoyed by the parents and the child. But if they don't like it, you can only go so far. It's to say, I can only take it down within my control. But these other folks, you may actually have to tell Instagram to take it down. And they do have policies. If you look at their terms of use, they have policies of who to contact if you need to take down an image. Yeah. They make it easy. Try to make it easy for you.
So we just had a question come in that's really relevant too, and that's protection for themselves. So we just have a question here that says, do we need a protection for ourselves too? That if people take images or I believe connect from our website, it goes both ways. So can you talk a little bit about what protections a business should have? I suppose their images are not being taken.
Yeah, so businesses are different, right? Businesses, they don't have fundamental privacy rights in their image and likeness. Those all apply to individuals, to basically people. Businesses have other sets of rights that they need to protect. That's really going to be, well, they need to protect the privacy of their employees and their customers. So to that extent, those privacy rights apply. But the most powerful right actually that you can use to block and cease and desist or demand a cease and desist of use of an image is copyrights and trademarks. Those are really important for a business to really utilize. I would even say trademarks are the most important for service business to use and utilize. Now, right now, at a scale that you're at, it may not make sense. But at some point, when you start to get more visibility, and if you're in a competitive industry, I know with music schools, it's highly competitive. There are a lot of schools opening up every day, right, by different instructors. So trademarks are very powerful, and it's not that costly in this grand scheme of things. They're about $3.95 to file. There are people who will do it for a flat fee. I recommend going to a practitioner. Don't go to LegalZoom. A lot of times, a lot of practitioners have to fix what LegalZoom said, and it may not be 100% bulletproof. So,
okay, great.
Trademarks are a good route.
And that's a good segue to our next kind of topic of questions here, which is, curriculum, content, and copyrights for what you're doing online or what instruction you're providing. So if we go to the first question here, one of the questions we got submitted prior, which is one that comes up, is what is fair use? And can you discuss how it works when teaching online? Especially in this like very online world where we can use content from various sources and have it online and someone else can see it. And, what do I need to get permission to use online in a kind of an online class setting versus maybe in an offline class setting?
Yeah. So fair use applies whether you're online or offline. And I'll be really quick with this because we're running up against the half hour. So fair use is a concept in copyright law where you as a individual or as a business, you can use copyrighted material. Now, if it's not copyrighted, it's in the public domain, you can use 100% of the work. And for commercial purposes, for educational purposes. If it's copyrighted, so copyrights means the work, the body of work that you're using, whether it's an image or a text or audiovisual file, that's all protected under copyright law. And usually there's a federal copyright that's attached to it, meaning it was registered with the US Copyright Office. If it is that, if you're using quotes or bodies of work or text or images, then you have to use it for educational purposes. And it cannot be used in a way that could be seen as commercial or damaging or diminishing the value of the copyrighted work. The courts, when this gets disputed, really look at that factor, whether it's your fair use, your education, even your educational use is diminishing the value of the work. And a lot of times, if you just use a portion, a quote, that's not gonna really diminish the value of the copyrighted work. But if you're using the entire, 90% of like a textbook and you're just regurgitating it and say you're gonna actually turn it into a series of webinars that you're gonna actually charge people, well, that's in the legal gray area now of almost commercial use, right? Because you're now monetizing off of it. You're almost using the entire body of work and say I'm not saying you're bad at it, but maybe you have a teacher regurgitating this stuff and they're really, brutalizing and damaging and not doing in a good way of teaching the methodology that's being quoted, right? That could diminish the value of the work. And there's an argument there that you're infringing, right? That you're damaging that copyright owner's work. So fair use has its limits, but absolutely, you can use the fair use for educational purposes of using copyrighted, copyrighted work. If it's not copyrighted, you don't even need to care about fair use. It only applies to copyrighted work.
Great. All right, moving right along here then. The next question is, who owns my content, right? So as we start to see a lot of classes migrate online, we're starting to see instructors teach through Zoom in a more private setting, but then also record those classes and post them on YouTube, or maybe they're doing stuff through Instagram TV as well. At what point who owns that content? Is it still me as the instructor, or is it these platforms? If I'm using a third party, how does that work?
Yeah, so you own your content, okay? But always read carefully the terms of use in every website you come across. It should say that the user grants a license, usually a or revocable, sometimes it's irrevocable. These are all legal terms, non-exclusive, royalty-free license, meaning you're not charging YouTube a license fee to upload and distribute and broadcast, or IGTV or TikTok to broadcast your content. But even though you own it, to what extent can you protect it? I think ownership really needs to be looked at in terms of, yes, do I really own this content when I produce it on YouTube or IGTV? You do own it. Look at the terms of use. 9 times out of 10, most of these tech companies are going to say you just grant them a license, meaning you give them permission to use your content. But the other side of that equation is, and this question really has more meaning, is, well, how much can I protect my content, right? If I just broadcast it, it's now out there in the public, you want to, again, have copyrights and you want to have trademarks. So sometimes popular YouTube influencers may have a trademark, or they may have a specific logo that's burned across their video, or that's in the info section of the upload. So you want to have some kind of level of IP protection or intellectual property protection.
Yeah, no, that's really good to know. Thanks, Eugene. So we're going to move on to another topic here that we get asked often, which is Zoom, which is what we're on right now, right? So one of the questions that we get, if we just move on to the first set here, is, we're using all this technology and we're still trying to figure out how it works, but are there any legal issues that we should be aware of through Zoom, right? What if someone gets the link on accident and joins the class? Am I responsible for a hack? If there's someone that comes on with a generic name, I don't know who they are, is that something I need to be careful of? And I think a lot of the questions that we get on this are specifically in context with children, again. Talk us through a little bit about that.
Yeah, so when you go on to a platform like Zoom, there are a set of rules called the terms of use, which I've mentioned earlier. They will govern your legal relationship with Zoom, and Zoom's legal relationship with you, and also Zoom's relationship with your student or customer, and that customer's relationship with Zoom. It doesn't govern necessarily the relationship between you as a business owner or instructor and your student and customer. You need to have your own separate set of legal agreements that cover that relationship. If there is a hack or a data breach that happens on a Zoom server, that's Zoom, that's all Zoom, and you look to their terms of use to see, and the privacy policy, which can also cover data breaches and what to do in that event. And you talk to them about what to do. And it's probably going to be you as a business owner, incumbent upon you and your responsibility to do that due diligence, to ask them, what are the certain steps that I need to take to protect information that's given to you, Zoom, or that's uploaded on Zoom, or that's through the use of Zoom. If you are having a website where customers and students are inputting information through the website, or it could be through email also, you want to make sure that that's also unhackable or protected, or the best practices of the industry are being used by your data server or wherever the information that the online information is being hosted and residing. And that's all data, right? Even first and last names can be considered protected information that's submitted online. You want to make sure that it's protected. And most large companies like Microsoft, they have standard protections. But if you are running a business where you are collecting a lot more sensitive information, especially health information, I really advise schools not to collect that kind of information on their students or customers. But sometimes if they want to have a special needs class, or they want to have a class geared towards a sensitive population with sensitive health care issues, yeah, you're going to have to make sure then that your service provider that has the data has certain protections, that HIPAA is in place, or certain personal health information is not, can be breached that easily. And you also might want to look at this cybersecurity insurance also as that extra layer of protection. One thing I didn't complete in the first set of questions was the two other, I said there's three, well, there's layers of protections. The first layer was your waiver and release. The other two is your best practices. You need to have effective communication and some sort of guidelines in place that are standard for the industry. Because if an injury, this includes even a hack happens, and you don't have certain guidelines around it, you could still be found liable for being negligent. And then you need to have insurance. Insurance is always a great way to protect yourself.
Eugene, let's talk about that. We've had a few questions come in here around insurance. You know, one is, I'll read them off and then maybe we can summarize, right? So do we need to purchase insurance for Zoom classes? And then the second piece that kind of ties into that is, does my insurance policy need to change to protect my company while online?
Yeah, so you should look at your errors and omissions and commercial liability and business owner's insurance. A lot of times they're intermingled, but professional liability, errors and omissions, and commercial liability are the insurance policy names that cover services and injuries or claims or occurrences that arises or relates to your services. So look at that to see, is there an exclusion for, is it tied to your physical property, or can it be anytime you render services anywhere remotely, including online? So it is worth a look. Talk to your insurance broker. It's not worth it to, I think, to get an attorney just to look at your insurance policy. Most insurance brokers are incentivized to do this work for you, and they should know the policies ins and outs and all the exclusions, because they might want to sell you that extra, rider or that extra additional policy, extra $20 a month. It covers online sessions.
Okay, great. So we have about 5 more minutes left in the webinar. The Q&A box is live and open. I see questions that are coming in. That's the set of questions that we're going to go through. So please keep adding to the box as I go through some of these questions. And it can really be on anything we talked about or anything we haven't talked about that you guys are curious, on asking Eugene as a legal expert. So I'm going to start some of these questions. Eugene, one of the questions we had come in is around, I might be the business owner, but then I have employees who are the instructors that are teaching online. What happens then in terms of legal protection? Is that the same? What do I need to know there?
Yeah, so I think that having a waiver with each of your business name is fine. That's compliant and that's sufficient to protect yourself. If you have certain instructors that are contractors in California, they could possibly be seen that they're most likely going to be deemed as employees, but that's a whole other topic, whole other webinar. But if you have contractors on staff, I would actually add them also as a party to the waiver. Having just your school's name is fine. I think having an instructor is nice to have to add additional notice. The way agreements work also is the more notice you give, remember the whole shouting concept, why we put stuff in caps in the agreement? It's to provide notice. So the more notice you give to your consumer, clients, your, mom and dad and their child, that this instructor is also covered in the agreement, the more protections and the more viability and the more, I guess, credibility you are in defending against a lawsuit down the road, because they knew that that specific instructor was also part of the course. But you don't need to have it. It's okay. Not necessary.
It's a nice to have. That's good to hear.
Yeah.
Okay, great. One of the questions we had also is around, I believe, around the template waiver that you're going to send out. Is that something that I can just insert my school name in and I'm good to go? How does that work?
So we're right up against that area of where I might be rendering legal advice, and because these laws, they're not black and white, and I know people don't want to hear that. The best thing I can do is give you a template that can be used in most cases, and which it probably can, without really learning the, just based on my own experience. I haven't done a statistical analysis on this, so please do not quote me, and have this waiver still looked at with an attorney, or you can even try to send it to your insurance broker. They are actually really great because they actually have templates also. A lot of insurance companies have their own templates because they want you to be covered. So you may want to reference my template with your insurance provider to see whether or not this will be this is a great thing to do. Also, if you're part of a group of other instructors or other teachers, just always use a community. That actually also creates a standard of practice and the standard of liability when there's a lawsuit. Is what are other people in your industry doing?
Right.
If this is in conformance with what others are doing, then that's protection. That's sufficient to say, hey, I'm not going over and beyond, and I'm not going super below what's standard. This is what's compliant, and it's going to protect me.
So another question is around, my classes are art classes or language classes. So they're not physical classes, where your children will be in their living room taking like a Tai Chi class. Is that any different when they're more kind of sedentary classes, or are these waivers and what we're going through today,
So this always changes with the different types, with the risk tolerance of each attorney.
Right.
I am probably, I would say 60% risk tolerant, meaning like I can be, I err on the side of being more risk tolerant than risk adverse. But even saying that, I do think that you should have a waiver if you are teaching minors, because of all the kinds of issues related to molestation, inappropriate behavior, things that could be misinterpreted. Even on a Zoom class, if they see a t-shirt or if they notice something that a teacher said or a gesture that could be misconstrued, that needs to be taken into account. And there is special kind of insurance that applies to child education businesses that covers allegations of assault, molestation, things of that sort. I know it's not a topic that people want to talk about, but if you're going to be teaching K through 12 students, you need to have some kind of, I think a waiver and release is important to have. Adults, less so for sedentary educational classes. But for classes involving minors, absolutely you should have that. And then look into your insurance to see if there's special insurance policies that for scenarios that you may not even thought about, and then talk to your peers. What are they doing also to protect themselves if they have special kind of insurance?
That's great. So we're going to answer one more question, Eugene, and then we're going to wrap it up and do a quick summary and some more housekeeping. So let's talk about the virtual classroom. So sometimes our instructors, they're teaching students, right? But they've got siblings in the room in the background, or maybe an adult taking the class with them, or a spouse in the room. Are they in my virtual classroom, even though they're not necessarily taking the class? Like, do they also need to be part of this? How does that work?
Absolutely. So yes, they have to have an agreement with you also. So if it's a parent that has 3 kids, hey, if one of them is signing up and then you ask them, hey, does they have a brother or sister and would they like to participate? And the parents say, actually, it's a good idea. Maybe they would. We do need to have them sign at least this waiver and release. So treat the Zoom classroom and that screen, that box, as if it's a physical classroom. So in a physical classroom, if you were teaching, even let's just say you're teaching, meditation, which is very sedentary, but hey, if a kid has asthma and you didn't know about it and there's breathing involved, you don't want to be in trouble for that, right? And it's the sibling of someone that is in the classroom, but they're just sitting there and they want to participate. You want to have them sign a waiver and release, right? Even though they haven't signed your teaching services agreement, or they weren't disclosed as somebody that's going to be an ongoing participant. you still want them to have signed at least a waiver and release at a minimum.
Okay. Great. Well, I know we have some more questions coming in, but I do want to be respectful of Eugene's time. So I'm just going to sum up quickly here. It sounds like, Eugene, and feel free to chime in. It sounds like first thing everyone should do is make sure they have a waiver in place. And after this webinar, we'll send out two things. First is a recording of this webinar. So you can definitely go ahead and rewatch it if you want to, or send along to someone who might benefit from the questions being answered. And the second thing we'll send along as well to all participants is a template of the waiver. So that's the first thing we went over. The second thing we covered, right, is around photos and videos releases, something to consider if you plan on recording or taking photos. And this is especially important if you're teaching minors, and knowing kind of the laws that govern minors online as well is something to think about. Lastly, checking your insurance and ensuring that they do indeed cover online classes. And then we talked a little bit about content and copywriting and whether or not you own it, and how to protect that content to ensure that it's yours and not distributed as other. Eugene, any other remarks to close out on here?
Yeah, so basically, we're not trying to eliminate 100% risk. That's impossible. Just take the point of view of risk management, right? We're managing everybody's little bubbles, right? That's what we're really doing as business owners, and managing also expectations. That's probably the business side of things. The legal side is really risk management. The business side is managing expectations. And that's really going to be fundamental in your communication, and your legal agreements are part of your business communications with your customers.
Great. Well, everyone, thank you so much for joining us. I really hope that you got a lot out of this webinar. And if you have any further questions, please email info@finli.com. Really anything related to this webinar or virtual classes. We're really here to support you as you come onto this journey of teaching online. And if you're not a Finli client and teaching Finli classes through Finli to different audiences, we're happy to talk to you about that as well. So I hope everyone enjoys the rest of your day. Thank you, Eugene, so much from Nano Law Group and giving your expert advice here. And with that, we'll close it out.
Thanks, everyone.